Okay, next, as far as Constitution of Company is concerned, we are moving on to the Alteration of Constitution. Okay, now what are the provisions which allow alteration or amendment to Constitution? I suggest you look at Section 36 and 37. Yeah, so Section 36 subsection 1 allows the company to alter or amend its constitution by special resolution. Okay, you can actually alter unless the constitution itself prohibits the alteration or amendments, but it is not advisable to prohibit such alteration. Okay, now if you want to alter, so you must pass separate resolution. If you want to amend constitution, you must have a separate resolution. Same thing if you want to abolish constitution or alter your current MAA or constitution, and eventually by replacing it with a new constitution. So basically you must actually pass a separate resolution for each of those exercises, yeah, whether to amend, to abolish, alter, replace it with a new one. So it should be a separate resolution. Okay, now Section 36 subsection 2 provides, okay, that particular constitution binds the company and the members from the date of passing resolution or a later date specified in the constitution. We have seen this, yeah. Okay, so Section 37 says that if you want to alter, right, or amend, you must use the procedure set out in the Act or in the Constitution itself. Yeah, okay. Now, when you wanted to alter constitution, there are few restrictions that you must actually adhere to. And the first one is that alteration must not be contrary to any of the provisions in the Companies Act. For example, yeah, if you want to authorize declaration of dividend, okay, whenever he has a profit, so basically if you alter this, you will actually go against Section 131 of the Companies Act, because this particular section provides, okay, you can only make a distribution of profits when your company is solvent. Okay, so if board of directors wanted to actually declare, so they must ensure the company is solvent after making the payments of profit. So this is in line with the solvency test. So this is where the directors should actually sign a declaration that upon payment of the profits, the company will still survive and they are able to pay the debts and liabilities. So there are actually few okay, few provision, few restriction which you have to follow. Okay, the second one, now if you want to alter constitution, such alteration must be bona fide for the benefit of the company as a whole. Now the rule is that, okay, you are allowed to amend, no problem, as long as whatever you do is meant for the benefit of the company as a whole. Okay, you can look at this case of Allen and Gorif, whereby this case involved a shareholder who has passed away. Okay, basically he has paid shares, okay, and unpaid shares. So some of it has been paid and some of it has not been paid. Remember, I've shown you the percentages. You can pay 30%, 40%. Now, if you remember the diagram of which I always show you, so this particular shareholders, yes, an accumulated areas of call. Areas of call meaning that every time they call up for you to pay your shares, but you fail, so it accumulates. Now, his asset of his estate. Remember, I explained to you about when a person died, leaving his asset. So we call estate of a deceased person. So his asset was insufficient, right? So now this particular company has this particular clause in their article saying that the company can have lien over those paid shares. What does it mean by lien? Meaning you can hold on to something. Now, that particular company, basically they issue special resolution. Okay, they wanted to alter the articles so that they can actually have lien over fully paid shares. Sorry, the articles only give lien over partly paid, but they wanted to amend the article to have it actually to have power or lien over fully paid as well. So what does it mean by having fully paid as well? So when they have this particular lien over the fully paid, so basically they can actually sell off those shares or transfer shares to someone else. Now, the lien over the deceased fully paid shares, if effective, means company entitled to apply the proceeds from the sale. So when they have lien, they have the power to sell those shares. So whatever amounts are received, okay, they can actually pay the unpaid shares. Okay. Now, company consequently be paid his debt over the deceased other creditors. So when you do this, in terms of priority, the company will be paid first. Okay, now, as shareholders, executor, remember when I explained to you last time on who are executor, who are administrator, remember, right? So, executors meaning they have been appointed, meaning these particular shareholders died, testate, basically died leaving a will. So, his executor brought action to invalidate the alteration of article, meaning they said that you cannot do that, right? Now, court held, this is the most important thing. Court held alteration is valid. Why? Right? Now, the court says, Master of Roll Lord Linley says, it can be exercised or it must be exercised not only in the manner required by the law, right? Meaning you must follow the rules, but also bona fide for the benefit of the company as a whole. And it must not be exceeded, meaning you can only do whatever is required. Right? So, although alteration directed against the interests of particular shareholders, meaning that particular shareholder, the deceased person, are at disadvantage because his fully paid shares are being held over lien, or are held on lien by the company. Now, the court says that they can do that. They can do it because the alteration was bona fide for the benefit of the company as a whole, because it seems that this particular shareholder has partly paid shares and partly unpaid shares, right? So what does it mean by partly unpaid shares? Meaning that particular shareholders are still owing some money to the company, right? Now, when they do this exercise, basically when they alter the article, so the company are able to recover the money owed to them, right? Okay, clear? So, basically there is no strict rules on what is actually benefit for the company as a whole. So, it is for the court to decide. So, it all depends on the particular facts of the case. You can look at the case of Shuttleworth, okay, as well as you can look at Greenhawk and other cinemas. Okay, I've put down in the slides here. Okay, now bear in mind, if it's meant to confer on certain part of the shareholders, it might not be, but it still depends on the interpretation of what does it mean by bona fide for the company as a whole. Okay. Okay, again, interpretation of benefit to the company as a whole will depends on the facts of the case. You can look at the case of Daphne template, whereby the court disallows it because it was not for the benefit of the company as a whole. Same thing, you can look at the case of Brown and British Abrasive Will. The facts are very clear and the decisions are very clear, very easy to understand. Okay. Please read those cases. Okay, next, alteration cannot avoid company for its contractual obligation under separate contract. The best case to look at is Carrier Australia Limited and Han. This is where the court held that the company had the power to alter its article, correct? But nevertheless, it was liable for damages for breach of contract. Okay, although they can alter the article if it's breach of contract, the company could not, if they alter for the purpose of to avoid any contractual obligation. Okay, so basically they cannot do it, right? The company could not avoid their contractual liability just simply by altering its article. Okay, you only do it because it's meant for the benefit of the company, but if you intend to avoid your contractual obligation, it is not allowable, as you can see in the case of Carrier Australia Limited. I suggest you look at you can search for the details of the this case Carrier in the website. Now, alteration must not deprive members' rights given to them by the court. So basically, you must also not allowed to alter if you deprive the members' right. So constitution cannot be altered so as to include any illegal clause. Okay, so that's all about constitution of a company. I have actually put up details notes in the slides given. Please read, try to understand, and we'll discuss it during lectures and during tutorials for all these slide and explanation. Okay, thank you very much.